All right. So hello to our audience. You are listening to the Gemini Legal podcast. On this podcast, we are interviewing subject matter experts, industry leaders, industry thought leaders, and we have a special show. This is our inaugural show, and we're broadcasting from the California Applicant Attorneys Association convention in beautiful Rancho Mirage. What a beautiful day. I am Dan Mora. I am not an attorney. I am a CEO and founder of Gemini Legal, and what we do is we provide legal discovery services to California attorneys. So my guest, I'm very happy to welcome Stephen Schneider, formerly CEO of MedLegal and currently CEO and founder of DocuSense. So very happy to have Stephen here. Stephen, why don't you do a little quick introduction of yourself?
Right on. So, quick introduction. Well, that's starting around the early to mid 1980s when I kind of got in this business. Actually, developing software for a company called SAK Photocopy, which I believe is the first lien-based applicant copy service. They started in 1978, and I was they were partners with Warren, and that business was sort of part of the deal. Mm-hmm. And yeah, one day Warren said, "You're going to take these computer manuals, you're going to learn how to program computers, and you're going to computerize this business." And I'm like, "Oh, okay, cool." So since then, started MedLegal in 1986, and just kept pushing until 2012 when we sold the company. And wow. I moved on to DocuSense.
Yeah, tell us a little bit about DocuSense.
So when I had MedLegal, obviously we had a ton of mail, and I'd go down into the mail room, and there'd be this sort of sea of handwritten envelopes and labeled envelopes, and everything, all types of mail, and nothing was aggregated. It was just not that well organized. And my dream was, man, all this stuff ought to come right out of a computer, print out, totally automated. And there should be no humans involved. And so that was my dream. And it kind of had those things back then, but they were super expensive. So I thought, make that specific to the niche of California workers' comp and all that mail. And aggregate it, make it easier for the recipients that get it, easier for the people that send it. So, kind of a labor of love, something a need that I thought I could tackle, and I needed something to do because I just sold my company in 2012. So that's what I've been doing.
Yeah, and that's since '86. That's 34 years.
It's crazy, man.
Experience.
34 years of fight.
Yeah, we were talking about that earlier. It's kind of, you have to have that fire in your belly.
Oh man.
Yeah.
Like nowadays, when people say, well, you got to watch out for that. You don't want to have to deal with lawyers, or this guy's pissed off at me because something, or threatening me, and I'm just like, it's not going to work because I've been through it all. I've seen it all. When you're a copy service, man, you're under attack.
You put in your time, and so what brings you here? And you put in so much time, but now you're hanging out with us. What's up with that?
Well, copy services make up a lot of my business for DocuSense. So what I figured out was, I obviously knew how much mail you guys generated. So when I needed to grow, I said to myself, I need to treat copy services like I used to treat applicant attorneys. I need to help them out, be there for them, build that trust, and then the business will come. And, thanks to companies like yourself and people like you to finally give me a chance not to be Steve of MedLegal and, Steve of a new company. Mm-hmm. And things are going well. So, it also helps me to feel, relevant. I have all this knowledge that goes on in my head, and every time changes come out, like this Monaco case, I'm interested in it, and I start reading it, and the fire starts, and I get interested, and I'm like, no, this is going to happen, and they should go this way, and so it's nice to be able to let that out.
Yeah. And we tend to we've been lacking somewhat of a voice in the industry, and I think that's part of what your motivation is as well. Is we need help.
Well, that's for sure. Yeah.
And that's a question. What do you see? We've had some attacks on some regulatory provisions and some case law. You just mentioned the Cole Monaco case, but where do you see this heading? Where do we go? How do we navigate?
You mean as copy services?
Yeah.
I actually think you guys are in a pretty good position. I think that Cole Monaco is bringing out the one issue I've been geeking out about for a long time, that I saw as sort of the hidden flaw, or hidden challenge, I should say. And I think it's come to a head. I think that you're going to find solutions one way or another, regulatory or legislative, or through the court. So we'll have to see how MedLegal chooses to handle that case. But future of copy service, I don't know. I think you guys are in a pretty good position, actually. You're about to get we're hoping you get this raise. They certainly put it on the table, and they didn't have to, so that's good news. I don't know. All right.
Yeah. The concern, I think, that we have as copy service owners is that it just doesn't stop. That there is an effort to completely reduce the need or the availability for discovery in the industry. And I'm curious how real you think that is. Is there an effort from whoever that are trying really to reduce that right, in my opinion, and the right of the injured worker to get discovery? I'm curious what your thoughts are on that effort that's behind the scenes.
I do think there's effort to create a single source, if not so much a single source. Whoever gets there first wins, basically. I mean, that's the way they've laid it out now, but the defense so rarely actually serves the records. They'll serve the reports. They serve what they want to serve, but it's not the same as subpoenaing records. So you might be right. It's another one of those sort of hidden things that you got to watch out for, that you guys are going to have to address and try to get around. But man, that's been the dream since I first started talking to those people in Oakland. Is they kept asking me, why are both sides getting the records? And I'd say, well, because they each want a certain thing. They each want to make sure they get exactly what they want. They don't want to be beholden to the other. They don't want to be waiting for the other one. So, and who would want their opponent in anything to supply them all the resources to play the game? I mean, that just makes sense. But of course, if you're a regulator and you're not a copy service or one of these guys, I get it. From the outside, it does seem a little silly. But then again, as the WCIRB pointed out after the fee schedule, the total cost of copy service in the whole industry is like 1% of medical expenses. That's what they came to. I mean, it's almost insignificant. So I'm hoping that fight to single source it at least has got a lot of the PSI taken out of that balloon. I mean, it's just not as important to them because there's not enough money there. Gotcha.
Yeah, that makes sense. I have concerns that single source, if it's not owned by the state, that you have questions of partiality in records. I agree that they would like that to reduce cost, but in my opinion, it flirts with the due process of both sides getting an independent look at the records. There's a labor code 5708 that gives the judges the ability to disregard statutory evidence rules, the evidence code, California evidence code, and I'm that to me is problematic. How do you feel about, or what do you think about that right for the judges to limit that due process evidence in workers' compensation? I realize it's administrative law, but we're still talking about justice here and benefits for injured workers.
Yeah, I'm not sure what you mean by they're taking away the rights. So 5708, which section? What does that
That
have to do with?
Yeah, it says that, and I can quote it, but it basically says that the WCB can, for lack of, I don't have the exact term, but can ignore the evidence rules and rules of procedure.
Oh, that's how so when you try to quote CCP, and everyone tells you, well, CCP only applies when it specifically says it applies in the labor code. Is that
Basically,
what you're shooting?
Right,
shooting
and
at?
correct. And then we've had some judgments, and we've had some commentary from judges that use that as a piece of.
So you say that your services aren't necessary because of why? I mean, how does that make it not necessary?
Do you see where it says evidentiary rules?
Yeah, I see where it gives the judge discretion on following the rules of practice and procedure for evidence.
Yeah,
but,
so that's the question. That's the question. For example, well, to be specific, so we're stuck in 4622, and some people would not use the word stuck, but the cement around 4622 or 4620 through 22 has been around medical, and they call it medical legal. Legal, we fall under the legal, and so we're having to prove that the claim is contested as to make 4622 applicable. Yet, in my opinion, the evidence is necessary to prove whether there's a contested claim. So that being backwards, and then judges having this discretion to leverage to not talk about or not include the California Evidence Code or the California Code of Civil Procedure in their justifications, then that to me is a concern. It's kind of, you can attack, I suppose, 5708, but or you could attack 4620.
Yeah, to me, it's 4620 through 4622. The only thing you're arguing about is payment. The only argument in the payment is, was there a contested claim at the time of your services? So if you're saying they're using 5708 to not look at the evidence that you're trying to put on to show a contested claim, I don't think you can do anything about that, because, yeah, you're right. A judge has discretion. They get to say, no, I don't want to see that kind of evidence you're showing me. I don't find it relevant. Show me something relevant to your issue and I'll accept it. So, where I see that whole fight is you have to put on evidence that either they denied the claim, or they denied some benefits, or they, the whole, you run through the scenario of denials. Did any of this happen? And then how do you prove it happened? I mean, there you got to go get some evidence. You can't just say it happened. You got to prove that it happened.
It's just, to me, it's just so backwards.
Oh, because you want to be entitled to be getting paid, and then they have to tell you why you shouldn't.
Sure.
That's what you mean.
Well, yeah, that to me would be logical. Like, discovery is important to the case, and it's possible, reasonable, and happens that discovery is delayed, and or the available, the open market for discovery services is hurt because of payment. So I know it's a chicken and egg question, tough question, but I'm concerned that it just keeps eroding. And
I mean, something's got to be done about the fact that you have to prove a contested claim. you're a service provider. Someone comes to you and says, hey, can you help me out? Can you go get these records? And you're supposed to say, well, now hold on. Let me ask you some questions.
Right.
And let me ask you for some documents to prove that you can talk to me about this discovery. I mean, yeah, that's an issue, but I mean, that whole concept of 4620, it was whatever it was, 4601.5 before that, or it is been around since I don't even know how long, but at least the 70s. So I know you don't like it, but I mean that's the way it's set up, and maybe I just look at it differently. I say, well, okay, that's a problem, and I just have to address the problem. And you're saying it's a problem, and I don't think it should be there.
Yeah.
And I'm saying, but it's there, and so,
Yeah, I've been given good advice that it's a very progressive movement. That if you have a movement of this, or from my perspective, and the theory that it shouldn't be there, yeah, we can get there. And I hear what you're saying. Yeah, but what we do need to do is focus on what we have now.
Yeah. Because you're generating AR as we speak, and that's one thing I think when people come from the outside, a regular business model, they kind of don't get. They think, well, everything's okay because there's nothing wrong right now, and I always try to tell them, yeah, but if I'm giving you this flaw to what you're doing, and just because it's okay right now doesn't mean it's going to be okay when you're actually trying to collect that 3-4 years from now. So. I mean, I get what you're saying. It's definitely, you got to be looking out ahead of this thing.
Right. Yeah. To me, it's a due process right. Discovery is. And if there's provisions that prevent or harm that ability, that do right capability, then that's dangerous.
Yeah. And I guess the argument to that is, look, it's been here the whole time, and you're here.
Yeah, I love that excuse. That's the way we've done it forever. Speaking about changes and long-term stuff, where do you see the digitization of records and mail? In my opinion, the security is the key. So we see a lot of security, tech security, being inserted into the legal field, and DocuSign and all those cool technologies that ensure security, so that the paper becomes less an authority. The digital record can be verified as an authority. The digitization of records is significant. When I started in this industry, I was not picking up records very often because, and I'm sure when you started, it was all scanning. You're just scanning or copying records. Mm-hmm. Now there's a significant portion that's digital that we get from the records custodian. Mm-hmm. How does that, though, affect mail? And my point with security is that security is the factor that allows people to trust the digital record as opposed to the hard copy, which has default trust.
Mm-hmm. Well, my theory on mail and what I'm trying to do with my company is, I mean, it's clear that paper's going away. It's clear it's going to just keep dwindling. What I'm trying to be is that clearinghouse that happens along the way while people still need paper. So typically when I pick up a customer, it's because they don't want to print and stuff envelopes, but really what I'm doing is I'm building a network, and I'm doing e-delivery, and I'm building all these different e-delivery transport protocols, because you may want stuff by FTP, and she may want by email. That person may be on Dropbox and Google Docs, and everyone may have their own flavor of transport and protocol that they want, using whatever security that they're comfortable with. Mm-hmm. And so where I saw the niche was controlling that, managing that for people. So, one day you can come to me and say, hey, Steve, I don't want paper from you anymore. I want it by FTP. And, I flip a switch and you're done. Mm-hmm. And then everyone's sending you mail. They don't even know the difference. Right? They don't have to change. They don't have to know your email address or your Dropbox address or any of that stuff. They know your physical address, and it just happens like magic. Mm-hmm. security for me is whatever the platform or protocol is that customer wants it in.
Right.
And if they want it in paper, because whatever, that's what makes them feel the most secure, then that's the way I give it to them. But it's an interesting argument when it comes to records, because there are people who felt that something like a blockchain platform is important for records. And when I think in terms of security for that, I'm thinking in terms of security for the injured person whose records those belong to. Not so much customers that are subpoenaing records. They kind of trust their service to get it right. And they're not really real concerned about how perfect that is, especially, when I was doing this work, we had a lot of customers that didn't want certain categories of stuff, and they wanted us to take that out. Don't give me all those notes or whatever it is, or lab reports. I don't want all these lab reports. And so you're not getting a complete record anyway. You've asked me to delete some of that stuff. You might have asked me in your language that I'm supposed to put on subpoena. We've already filtered out a bunch of stuff. So, I mean, what is this record we're trying to be so concerned about security and perfection for when we don't even know if the source was accurate? It's corrupted almost by default. So I think it's interesting, this concept. And I think that maybe in other types of law, maybe it would be important so that somebody didn't take something out that you were looking for that needle in a haystack. But knowing how most of the practitioners in the work comp field manage and use, the records, I just don't think they would. It wouldn't matter to them what security protocol you had.
That makes sense. I think you're right that the audience isn't, the receiver of the records isn't that concerned with that security. But we talk about single source records, and administrators and legislators, they like that. Yeah, they like that.
They're like, hey man, if it's guaranteed to be the same for everybody, then what's the problem? Well, the problem is the person who ordered those records in the first place could have easily set up in their language of records being requested stuff they didn't want in the record. And now what? Now you're stuck there.
Right.
And you don't know what you don't know. And you have no right to go find out what you don't know, which is your argument.
Yeah. Yeah, the bridge in the bridge. I come back to, nobody's gonna approve a bridge that is not put in place by legislation. If an attorney wants records from Kaiser, and at this point the government would have to require, in my opinion, they'd have to require a protocol from Kaiser to. And it wouldn't be easy for them, and it would be expensive for them, and they're going to fight it. So we're years kind of away from that, but they would have to, I think, set a protocol for the custodians, that records go in and they don't come out type of protocol. Inspection, I don't know, audits, who knows how that's all going to shake out. But I think we're on the same page. That's years away.
Yeah, it's years away. I mean, when I was trying to sell my company, I started trying in like 2010, 2011, and that's what they wanted to know. They wanted to know, what about digitization? How is that going to affect things? And I told them then, and I think it's true now. This is about discovery. It's not about what medium I handed the information on. It's and you talk about this too. It's independent right to discovery. Taking that away from somebody, I just, that's not going to go well.
Right.
And we don't do it in the civil world. Well, the argument is, because everyone pays for their own stuff. That was the grand bargain that they gave to the workers in the Workers' Compensation Act. They were going to give up a lot of their rights to a jury trial and, big dollars, but they were going to get all their costs paid for, and they were going to get an administrative system. And now, one by one, well, we're not going to let you choose your doctor. We're going to make you go through NPN. We're not going to let you choose your QME. We're going to make you use a panel with the strike. You're going to wake up one day and it's going to be there's an NPM of copy services, and you get to use any of the copy services on our list. that the state approves. I mean, that would suck.
Yeah.
At the same time, it seems like we always find a way around whatever, BS, almost unethical to me. I mean, I got a bias, okay? But this friction that they put on it, in that situation of a single provider for records, I think they would have to have a provision of, for any one record. And so even if one side got records through a subpoena with kind of some generic language, and then the other side said, I'm looking for this specific thing.
Yeah.
I think that's how the system would be gamed, and it would kind of stay mostly the way it is, because everyone would be saying, well, it wasn't exactly what I wanted, so, I went this other way. And I mean, how many times have you gotten a complaint from a customer where you got a CNR and they say, there's records there, and you're like, I did everything you asked. I went to the place. I mean, what am I supposed to do?
Yeah.
And I can remember back in the day, people just adamant, just lawyers just pissed at me, and I'm like, you tell me what, you're the lawyer. What do I do next? They've signed this.
Yeah. Yeah, and I when I'm asked about the digitization of medical records, and it's changed in the last decade a lot. We are a legal clearinghouse. That's our job, is to inspect and make sure that what was asked for was what was provided. Just as you pointed out, a single source, it's a little scary. Unless that single source can guarantee that they always get everything. But I don't know how you do that. Yeah. So
and then you try to get everything, and they say, I didn't want all this crap.
Exactly. Catch-22. Well, fun. So last question. You have a magic wand, and you could change anything. You could even talk about the Astros and the Dodgers if you want. No, I'm curious. What is there a magic bullet here? What bright idea do you have? Something that could change this whole game we have here in workers' compensation.
In workers' compensation, or for the copy services?
Oh, everything. You just world peace, Stephen.
I don't think there can be world peace, and I don't think there can be world peace in work comp. I focus on just the stuff that's in front of me and in my head all the time, and but this Monaco issue with contested claim, I think it just needs to be either legislative or regulatory. Just clear it up. Just say what you want, instead of what typically happens with almost all of our regulations. There's a simple way to say it and make it clear, and I don't know why it just doesn't seem to happen.
Yeah.
And so you end up with people, you read 9982 and I read 9982, and then you pop a question, and you might say no, that doesn't cause a problem, and I might say, oh yeah, 9982, A2. It shouldn't be like that. It's just be clear. So if I had a magic wand, I'd clear up the whole what is a contested claim for discovery in workers' compensation. And man, if I had that and I were a copy service, I'd be happy. I think it'd be a
there seems to be a resistance to our subject matter expertise. You and I both worked with legislatures and administrators, and we see it so simple. Just listen to us. We're not trying to get over on anybody, but that's politics, right?
Trust is so hard to come by.
Yeah, very good. Good ending on trust, Steve. Thanks for coming on to our podcast. I really appreciate your time.
Thanks for having me. This is fun.
Very good. Well, you have a wonderful day.
All right, you too.
All right, take care.